accessible to all in litigant-friendly manner. The web page of the Calcutta High Court has also been designed in a litigant-friendly layout, which is to be rolled out soon. Most of the things that a litigant needs to know about the court or its functioning are available on the web page. For example, annual reports, calendar, information relating to case status, orders, judgments of a or particular information relating to commercial courts, display board of the mainland and the circuit benches, e-filing, e-gate pass, e-library are accessible through the web page. We are working on creating e-SCR, e-pay, e-RTA application, e-RTA status platforms, and they would be functional shortly. Other initiatives like Justice Clock for the High Court and the subordinate judiciary, introduction of, the district judiciary, introduction of e-ACR through personal information system for the judicial officers, Android mobile applications for the High Court, orders and judgments using neutral citation have been undertaken. Last but not the least, the only silver lining of the pandemic, that is virtual hearing, have come to stay. Virtual hearing is available in all the courts to the litigants from anywhere in the world. Live streaming is another endeavor of the digital era, which we have accepted and adopted. Though not free from its concomitant irritants like trolls, etc., live streaming of hearings have enhanced transparency and accountability in the judicial process. We are in the process of implementing the initiative on paperless courts. In compliance with the desire and directions of the Honorable Chief Justice of India, the task of translating the reportable judgments of the Honorable Supreme Court of India, as well as the High Court of Calcutta, is being done with the assistance of the SUAS tool, under the supervision of a committee of honorable judges constituted for the purpose. The website of the Calcutta High Court has been made accessible in terms of the directions of the Honorable Accessible Committee of the Supreme Court of India. Now, cost lists can be generated in HTML format for visually challenged persons with appropriate screen reader. Steps have also been taken to make the High Court building accessible to the physically challenged. In the era of tremendous technological advancement, we have taken measures to equip the district judiciary with the latest hardware equipment for enhancing productivity. We have provided judicial officers with high-end laptops, and speech dictation software are in the process of procuring digital law library for the judicial officers. We have already implemented the FASTER throughout the state of West Bengal and Andaman Islands. This would not have been possible but for the financial sanction provided by the government of West Bengal. We are proud to mention that the Honorable E-Committee of the Honorable Supreme Court, in their special edition of the newsletter, has elaborately showcased the various e-initiatives and best practices adopted by the High Court of Calcutta. We convey our sincere thanks to the Honorable Chief Justice of India. As a step towards accountability, we are publishing annual report, enumerating yearly achievements and charting out a vision for the future. The first annual report was published in the year 2023, would show that in the last 5 years, we have been able to increase our disposal rate. As on 1st January 2019, the rate of disposal was 111.16%. As on 1st January 2020, the rate of disposal was 81.72. As on 1st January 2021, it increased to 110.67. And as on 1st January 2022, the rate of disposal was 123.93%. And as on 1st January 2023, the rate of disposal was 120.84%. We are improving our rates of disposal. In sync with the laudable initiative taken by the Honorable Supreme Court of India for arrear reduction in the district judiciary, we are almost in the process of completion of the first phase of action plan formulated by the Honorable Apex Court. District case management committees have been formed in all the districts to deal with the issue of arrear reduction. Considering the pace at which the implementation measures are proceeding, we are confident of achieving the target of arrear reduction within the stipulated time. The Calcutta High Court is facing space crunch. The Honorable Chief Minister has been gracious enough to hand over 9 floors of the new Secretariat building adjacent to the Calcutta High Court main building. We thank you, Madam, for the gesture. The state government has allotted to the High Court for the new High Court complex land for such purpose, which in my personal opinion may not be sufficient considering the future requirement, say for the next 50 years. And the High Court will request the Honorable Chief Minister to consider and allot a larger extent of land. The work of construction of the circuit bench of the High Court at Jalpaiguri, High Court at Calcutta at Jalpaiguri is nearing completion, and we expect to inaugurate the grand structure very soon. West Bengal Judicial Academy was established in the year 2005. The academy had its humble beginning from Bijan Bhavan. The High Court Guest House. On 25th of February 2017, the academy building was inaugurated. Incidentally, Honorable Justice Dipankar Datta, who's present among us, was one of the members of the committee and had taken keen interest along with the then chairperson, other members, and the then director of the academy in the construction and commencement of the building. To cater to the growing needs, the Judicial Academy proposed an expansion of the infrastructure by increasing the hostel strength and building a state-of-art auditorium, among other facilities. The proposal was accepted by the government of West Bengal, and a sum of rupees 48 crores 62 lakhs 33,034 has been sanctioned. The Academy has undertaken significant measures to improve the quality of judicial education imparted to from its portals. It has partnered with international organizations like Central and East Europe Law Initiative to train master trainers in specialized area. One such program on anti-human trafficking was undertaken on 3rd and 4th February 2024, and another on transnational crime is scheduled to be conducted on 20th and 21st July 2024. Yesterday, the Honorable Chief Justice and other dignitaries released the primer, a pioneering effort of the West Bengal Judicial Academy under the chairmanship of Honorable Justice Joymala Bakshi for the purpose of capacity building of judges. It is a momentous occasion for the High Court at Calcutta and the West Bengal Judicial Academy to host such a luminous gathering. I hope it's a memorable experience for all of us, and it enriches and empowers us to serve the cause of justice and the people of our nation in a better way. I thank my brother and sister judges for their unstinted support, guidance, and assistance rendered to me both during my tenure as AD1 and after becoming the Chief Justice. I have very interesting anecdotes to share about each of my brother and sister judges. However, due to paucity of time, I am unable to do so. All that I can say is they all stood by me, helped me in discharge of my administrative functions. I convey my sincere thanks to the Learned Registrar General and the Learned Registrars, past and present, officers of my secretariat and other officers and staff for their tireless effort put in to enhance better functioning of the Calcutta High Court and to make the program a grand success. I'm sure your Lordship's stay in Kolkata is comfortable, and if any other requirement is to be met, kindly let us know. We shall ensure the same. I once again extend a warm welcome to their Lordship and to one and all. Thank you. Jai Hind.
Thank you, my Lord, the Chief Justice, for the welcome address, which I'm sure has not only warmed the cockles of our hearts, but has also indicated with sufficient clarity the purpose, direction, and the ultimate goal of the Honorable High Court at Calcutta, the Judicial Academy, and this conference. His Lordship's insights and visions will undoubtedly set the stage for productive discussions and meaningful outcomes.
The time has come to request the Honorable Chief Minister of the State of West Bengal, Srimati Mamata Banerjee, to say a few words. Madam Chief Minister, if you may please.
Thanks a lot for giving me this opportunity. I deem it is my proud privilege to be with all of you. And we are honored, our Honorable Chief Justice of Supreme Court of India, Honorable Chandrachudji is here. And you know, Chandrachudji's, this name is very popular because his father was also, and generation to generation, they are busy with this work. and they serve the country and the people for a greater sense. So no need for introduction, but need for his revolutionary steps for digital India and for e-law system. Mr. Gawa, thank you so much for coming over here. Bindalji, Aniruddha, sorry, I should not say Aniruddha, but our Bengali, the habit is Dada and Didi. It is to give them respect. So, Mr. Aniruddha Bosh, Dipankar Da, and Dipankar Datta, আমাদের চিফ জাস্টিস অফ ক্যালকাটা হাইকোর্ট, আমাদের হরিশ ট্যান্ডনজি, জয়মাল্য বাগচিজি, আইপি মুখার্জি, অ্যাটর্নি জেনারেলজি, my colleague, Law Minister Malay Ghatok, my Finance Minister Chandrima Bhattacharya, all the judges of Calcutta High Court, and all the judges from District Judiciary and Northeastern part also, and all the registered also. I don't know what to speak, but please consider me as your family member, because I also belongs to this law fraternity. In my life, 3-4 cases I also fought, and they offered me one ground. I preserve it. Whenever I'll be allowed to practice regularly, not for me, but for public works, for development works. And sometimes I have seen to give the briefing, it may not be proper in every cases. So it is better if we can fight ourselves, then at least who knows the things, at least may get the opportunity, because now also I am continuing the Bar Association membership. So please give me the live member. Every year giving the subscription, instead of that, give me the live membership, so that sometimes we also on behalf of people, I can assure you no money we will take for that, only voluntarily. Sir, thank you very much. This judiciary is an important temple for us. It is just like Mandir, Masjid, Gurudwara, and Girja. It is our supreme authority for delivering the justice to the people, the last frontier for getting justice and upholding constitutional rights. I believe this judiciary is government of the judiciary, by the judiciary, for the judiciary. No. Government, this judiciary is of the people, by the people, and for the people. If judiciary cannot help us, means not me, the common people, then where the people will get the justice? When the people, any problem comes, when we have seen some atrocious, terrible things, then only we hope with a greater interest that only judiciary can solve this problem. And we just watch judiciary. We think they are our the big pillar of the foundation of this country to save the democracy, to save the constitution, and to save the people interest and everything. We are honored and grateful, and I think our privilege that Mr. Chandrachudji has initiated so many things, especially for digitization and e-judiciary, e-legal system. In our state, we are e-governance, we are number 1, sir. You'll be happy to know. And in our state, we have already Honorable Chief Justice of Calcutta High Court has mentioned, we gave 1,000 crores we already spent for judiciary for development. Also, we provided 70 acres of land, and also we provided land for another new high court. That's a Rajarhat. It's a posh area. You asked me one building, I gave it next day. I vacated this building for government, and next day I provided this. We have 88 fast track court, though earlier Attorney General is here for his information. Earlier, Government of India should have provided the assistance for this fast track court. But before 8 years ago, they have withdrawn all these facilities. But now we are running, we are the only state we are running 88 fast track court. Out of that, 55 women fast track court. And also we have 6 POSCO court. We have 19 human rights courts. We have so many courts like this. And also Jalpaiguri Circuit House, Circuit Bench also, it is new one. And our judicial academy, it is one of the biggest academy in the world, and it is very popular. We are proud of our students, and whoever is coming from the judiciary, they are the asset of the country and the asset of the world. Only my humble request will be to all of you. First, I want to apologize to mention this to all of you. It is not my intention to humiliate or manhandle to anyone, but my submission, my kind submission, that please see no political biasness in judiciary. Judiciary must be pure, absolutely pure, honest, secret, and let the people do the puja. Like Sanskrit, they say sometimes puja, sometimes um, for all the caste, all the creed, all the community, all the people. Even northeastern people are here from Andaman. They are really neglected. Give them bigger opportunity. Sometimes to come to Calcutta and other place also for their greater interest, because nobody takes care for them. They're really neglected. I will appeal for them also. With this word, thank you very much for convening this conference here. And please do it in every time. From our side, there are so many places are available also. I thank to ITC for organize all these things. West Bengal government, my chief secretary, my police commissioner, my law ministry, my finance ministry, and all. But and press media and all. But at the same time, I will request you do it more and more so that we can interact and we can open our mouth also. Thank you very much. Thanks a lot.
Thank you, Madam Chief Minister, for the special address. And now the honorable dignitaries present in this August conference, brothers and sisters of the District Judiciary, ladies and gentlemen, may I now call upon the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, to give voice to the keynote address. My Lord, the Chief Justice of India.
Namaskar. Honorable Ms. Mamata Banerjee ji, Honorable Chief Minister, my brother judges, Justice Bhushan Gavai, Justice Dipankar Datto, Justice Rajesh Bindal, Chief Justice of the Calcutta High Court, Justice T.S. Sivagnanam, Honorable Judges of the Calcutta High Court, Mr. R. Venkatramani, the very distinguished Attorney General for India, Justice Aniruddha Bose, Dada for us, who's been a very valued colleague and now the Director of the National Judicial Academy, the Law Minister, Finance Minister of the state of West Bengal, all the dignitaries who have come, judges who have come from across various states to attend the regional conference, ladies and gentlemen. The State Judicial Academy and the Chief Justice of the High Court could not have chosen a more topical area for our discussion over the next 2 days. Essentially, this conference speaks of contemporary judicial developments and strengthening justice through law and technology. The word contemporary is very important because it does not speak about the work which we do in the abstract, but in the context of contemporary societal challenges which we as judges face in the work which we do. We therefore look at law and its intersection of technology from the perspective of the societal conditions in which those whom we serve exist in our societies. Because the true merit of our work lies in addressing the challenges faced by those at whose feet we are intended to serve, namely the common citizens of India. The first important theme that we are going to discuss is the principle of constitutional morality. Now, if you look at the Constitution, the text of our Constitution does not use the expression constitutional morality. This phrase, into invert commas, constitutional morality, is not found anywhere in the Constitution. The Constitution uses the expression morality, but it does not use the expression constitutional morality. Now, all of you may be asking a basic question, which is, why are we discussing a phrase which is not used in the Constitution at all? What is the relevance to district judges, high court judges, to the officers of the state, to civil society, of a phrase which is not used in the Constitution? The Constitution uses the expression morality, but morality in the Constitution is used as a restraint on fundamental rights. The Constitution allows for restrictions to be imposed by law on the right to freedom of speech and expression under Article 19(1)(a) by Article 19(2) on various grounds, including morality. Likewise, the Constitution contemplates that restrictions can be imposed on the right to freedom of association, inter alia, on grounds of morality. So morality in Article 19(2) and Article 19(4) is a restraint on the rights of the citizens. Is that the morality that we speak of when we talk about constitutional morality? Now, that's one of the basic questions which we have to address. If constitutional morality has not been addressed in the Constitution as a textual expression, what is the value addition to the constitutional discourse that we in a regional conference, a high-powered conference of senior judges from across the region, are discussing this concept? There's a first question which I must very briefly try and make you all perhaps reflect on. How do you define what is undefined and what is not explicitly stated in the Constitution? Who will define the concept of constitutional morality? We exist in a federal structure. We exist in a federal structure which is marked by a great deal of diversity. I was born in Mumbai, belong to a small village about 60, 70 kilometers away from Pune. My work took me to Allahabad as Chief Justice for 3 years. And now I look at the broader context of the Indian nation. And one thing which cannot but leave a very imperceptible mark on your heart and soul in the work which we do as judges in Delhi is to realize the importance of preserving the diversity of India. So how do we then dwell on the concept of constitutional morality? At one level, constitutional morality is founded in the preambular values, the values which the constitutional preamble sets out. But if these rights have already been enunciated elsewhere in the Constitution, then why constitutional morality? In fact, I was one of those who applied this concept of constitutional morality when I wrote the judgment in the first round of the battle between the NCT of Delhi and the Union of India about 6 or 7 years ago. And responding to that judgment, the learned Attorney General for India, Mr. Venugopal, asked me in another case, he says, Judge, where do you find this doctrine in the Constitution? It was an academic discourse as constitutional cases involve. At a certain level, the preamble defines concepts and refers to concepts such as justice, social, economic, and political, liberty of thought, expression, faith, belief, and worship, human dignity, equality, fraternity. Now, these rights, which the preamble refers to, are found in the text of the Constitution. Article 21, the right to life and personal liberty, equality in Article 14. Then why are we evolving this concept of constitutional morality? There is a more deeper reason. And that deeper reason for us to dwell on the concept of constitutional morality is that constitutional morality is an overarching principle which is derived from, but is not confined to, specific rights or values which are enshrined in the Constitution. Constitutional morality gives you a unifying constitutional ethic. It gives you a unifying constitutional ethic so every Indian citizen can think as she wishes to think. Every Indian citizen can speak as she wishes to speak. Every Indian citizen can worship as they intend to worship. Every Indian citizen is entitled to follow whoever they want to follow. Every Indian citizen is entitled to eat what she or he wants to eat. Every Indian citizen is entitled to marry whoever she or he wants to marry or not marry at all. In other words, what constitutional morality really opens up as a universe for all of us, particularly as judges, is to create a whole way of life which the Constitution has created. And that way of life is deeply cognizant of the fact that India does not exist only in large cities, but it goes down to the smallest village and the smallest taluka across the nation, connected or not connected, communicable or not communicable, accessible or otherwise. And that is the true merit of the doctrine of constitutional morality. Constitutional morality, unlike morality, as I began by telling you, morality is a restraint on the rights of citizens. Constitutional morality, on the other hand, addresses itself to the state. Constitutional morality is a restraining factor on the state. But besides being a restraining facet of what the state has to respect, it imposes a duty on the state to facilitate the achievement of the kind of society which the Constitution envisages. Constitutional morality addresses itself to every component of society and to society as well. The Constitution is not merely a dialogue between the state and its citizens, or between the union and the states, or between the states and states. It's a dialogue within and between societies. And constitutional morality addresses itself to every component of society, and the society itself telling society that you must allow for conditions which respect diversity, promote inclusion, and pursue tolerance. The heart of the nation is our realization of the importance of diversity, the need for inclusion, and the ultimate pursuit of tolerance, which defines why we are, 75 years after the birth of the nation, still a nation with such beautiful diversity and colors. But above all, since we are judges, constitutional morality reflects an institutional commitment of the court system, the institutional commitment of each one of us that we are but subservient to these values of the Constitution. Too very often, when we are addressed as honor and we are addressed as lordships or ladyships, there is a very grave danger, and people say that, well, the court is a temple of justice. There is a danger that we perceive ourselves as the deities in those temples. Therefore, speaking for myself, though I have my own set of personal values which are deeply personal to me, I'm a little reticent when I'm told that this is a temple of justice. Because temple postulates that the judges are in the position of a deity. I would rather recast the role of the judge as a server of the people. And when you regard yourselves as people who are there to serve others, then you bring in the notion of compassion, of empathy, of judging others but not being judgmental about others, allowing other people to lead the lives as they lead. All of us know as judges that in the worst of criminal cases which come before us, we have a human being who is before us. And even when we exercise the power of sentencing, we do that with a sense of compassion, just as we do it with a sense of duty to the family of the victim who has been wronged. So it is these concepts of constitutional morality which I think are the key, not just for the judges of the Supreme Court or the High Court, but for the district judiciary itself, because the engagement of common citizens begins first and foremost with the district judiciary. The Supreme Court is the court of last resort, notwithstanding Article 32. The court of first resort are the district courts across the nation. The second aspect which I want to dwell on is why technology. All of us as judges have worked in conditions which are good, conditions which are not so good. There is a variety, a wide variation in the manner and conditions in which our judges work. What is the relevance of technology to common citizens? The reason why I thought I must mention this, which is the second theme of the conference, is that our mission towards technology, which I've really advanced as almost a mission of my life over the last 5 years that I've been chairing the E-Committee of the Supreme Court, is not that we want to modernize the Indian judiciary for the sake of modernization. Modernization is ultimately a step in aid of something else that we want to achieve. The government expends large funds on modernizing the judiciary, and technology is no exception. Phase 3 of the e-courts project, Justice Bindal is going to chair that session, has an outlay of 7,000 crores. Now, what is the purpose of this 7,000 crores to the lives of common citizens? That workman whose services have been terminated, the tenant who is being evicted, that man in the farm who wants a mutation entry, a partition suit between brothers which is pending for so long. What is the relevance of technology to common people? First and foremost, and I'll highlight 3 facets. First, in the work which we do as courts, language is a central barrier to accessing justice and understanding the work which we do. First, all our textbooks are written in a language which is unknown to common citizens. Mullah's Transfer of Property Act in English, or Sirvai's Constitution of India, or D.D. Basu's Constitution of India, the shorter Constitution of India. How does the common citizen access those seminal words of the text which are meant for them? But technology can provide us with some answers. Language is a real problem. 37,000 judgments of the Supreme Court since independence have all been written in English. But these judgments deal with common citizens' problems, that right of maintenance to the woman, the right of someone who's accused of an offense under Section 498A to seek bail, the right of a person who's subject to a very serious offense to ensure that the offender is tried in accordance with law expeditiously. Now, technology has enabled us to translate the judgments which we are writing. And I'm glad that this mission, which we began in the Supreme Court of translating, we have translated over 51,000 judgments. As I said, there are 37,000. But we are translating the judgments of the Supreme Court in every language which is recognized by the Constitution, including Bangla. I had to emphasize Bangla and Odia because my wife is very fond of Odia. Being an Odia and being very close to Bangla, of course, that's in a lighter vein. But apart from that, the purpose of doing all this in every language which is recognized by the Constitution is to take the work of the court to the homes and hearts of common citizens. And we are using machine learning software, AI assisted software, for the purpose of translating these judgments, and the mission is on. Judgments of the Supreme Court has been translated into Bangla, into Tamil, into Gujarati, into Marathi, into Urdu, into Nepali, into Assamese. Every language, the work is on with the use of technology. Another very important aspect. To access a judgment of the Supreme Court, and I dare say for the High Court as well, any young lawyer has to first and foremost subscribe to a law report. How many young lawyers can afford the cost of spending, say, 40 or 50,000 rupees a year for the purpose of subscribing to a judgment of the Supreme Court? Simple question. We write the judgments, but the judgments are on sale by private publishers. The delivered judgment is available on sale by private publishers. Is this not something that we have to remedy? Because we are the people who write the judgment. Is it not our duty to ensure that once the judgment is delivered, that it is made available to common citizens and to lawyers, young lawyers? And this is a part of changing the social character of the legal profession. Because who appears for the smaller citizens? Not the best lawyers in Delhi, not probably the best lawyer in Kolkata or in Mumbai or Chennai. Those who appear for the workers, those who appear for those small farmers, the marginalized citizens, are those who belong to their communities. Therefore, we have to make our judgments available. And that is why we have now set in motion the digital Supreme Court reports. The digital Supreme Court reports is a free resource which we have provided for judges and lawyers across India, which makes available all the judgments of the Supreme Court in a digitized form, freely available on the website of the Supreme Court. This is an effort to promote legal literacy, to allow for young lawyers who have no resources to pay to subscribe to these judgments. Second barrier, distance. Litigants can't come to the capital of every one of our large states, and West Bengal is no exception. It's a very large state. Maharashtra, where I grew up, is a very large state. Uttar Pradesh, where I had to do my work as a Chief Justice, is an exceptionally large state. How many litigants can actually come to the court, sometimes only to be told that ye to tarikh pe tarikh mil gayi? That means we are essentially ousting the litigant from the process of dispensing justice in our courts. Video conferencing, which was initiated during COVID-19, has two clear benefits. It provides for decentralized access to justice. Across India, there are demands that benches of the High Court should be created at more than one place. The Calcutta High Court, of course, has a bench at Jalpaiguri. It has you even have a bench at in Port Blair. Just as the Bombay High Court has a bench in Goa, apart from Nagpur and Aurangabad. Allahabad has a bench in Lucknow, so many others. Madhya Pradesh has a bench in Jabalpur, in Indore, and Gwalior. Jabalpur, the principal seat. Now, what technology does is to allow for decentralized access to our courts. Why should access to the High Court, or for the matter, the Supreme Court, be confined to one location? I always ask myself the question, is the Supreme Court of Tilakmarg, or is it the Supreme Court of India? Physically, we are situated in Tilakmarg, but we must open up the access to our courts to lawyers and citizens across India. Each citizen must know that the smallest case which comes to the Supreme Court, and that is a criticism of us judges, people tell us, why do you take up these small cases? Why are you so concerned about somebody who has been denied bail for an NDPS offense? My answer is very simple. Somebody who is a carrier in an NDPS case, for instance, or somebody who is guilty of a small assault and who is in jail for 8 months, 1 year or 2 years, will the Supreme Court not look at them? Now, the reason why I mention this is that technology allows us to listen to lawyers from across India to hear the voices of those who are closest to the clients. That promotes a great deal of confidence in the work. Citizens have a great deal of confidence when they realize that the smallest case of pension, lost in bureaucratic apathy, nobody is deliberately denying anybody pension, but bureaucratic apathy. When you have a bureaucracy, there's bound to be bureaucratic procedures. That citizen is entitled to know with what seriousness my work is being attended by the Supreme Court. The third important barrier, the lack of awareness of court procedures. A citizen does not know what procedures are involved between the time that a case is lodged in the filings counter of the court to the first hearing in the Supreme Court. E-filing, which we have adopted, and not giving you all the figures because I thought giving you all the figures and the great success story, every success story also tells us of still the work which is to be done. So I'm not giving you only part of the statistics. That's not my purpose. I thought I'll speak to you heart to heart. E-filing enables citizens to have streamlined access to justice. For instance, in the Supreme Court, we have been able to establish that a case which is filed by a particular date shall be listed before the bench for the first hearing by a particular date. In many high courts, for instance, I'm very deeply concerned about the fact that even urgent applications for bail will not be taken up for months on an end. This can't be the model of an ideal judicial system which we are adopting. We must give to citizens an assurance that a case which is filed by a particular date will be placed on the bench in the hands of a court which will deal with that grievance by a particular date. The National Judicial Data Grid. The National Judicial Data Grid is a mine of data, pending cases, disposed of cases. It goes down from the central level down to the last small court in the taluka. It has drill down features going down to the last case. End step. As you all know, the greatest difficulty with a litigant faces is trying to serve a summons on the defendant. The defendant will be away from home, away for a marriage, in hospital. 20 different reasons why a summons cannot be served. The poor plaintiff will languish, trying to at least get the summons to be served. Technology has given us a very simple solution, which is the end step. The end step is a simple phone which works on a GPS, which identifies the location of the process server. When the process is served on the defendant, it will log in by the means of GPS when it was served, takes a picture and logs it onto the server. That's end step. Interoperable criminal justice system. Somebody who lodges an FIR, has the FIR been registered? What is the action taken on the FIR? It enables us to lift every aspect of an FIR as judges that we want to know in the course of the hearing of a bail application. Faster, which Brother Sivagnana mentioned. The Supreme Court grants bail in a case. How do you ensure as judges that the order of bail has been implemented? The other day, I came across an order of bail which was passed by one of our high courts. The judge of the high court, while disposing of the bail application, directed the trial judge to impose stringent conditions for the grant of bail, because the offense was, according to that judge, not a fairly serious offense. What the trial judge did was, while imposing the bail conditions, he directed a cash deposit of 10 lakhs with a surety in the like amount. 7 months after bail was granted, the lawyer was before us saying, for 7 months, my client is languishing in jail because I have just not been able to put up the kind of surety for the grant of bail. So we have now developed a system called Faster in the Supreme Court. The system operates on the basis of blockchain technology. After an order granting bail is passed by the High Court or by the Supreme Court, the implementation of the order has to be ultimately done by the district judge and then ultimately the jail superintendent. Has the copy of the order been served on the jail superintendent? Has that order been made available to the district judge for implementation? And what action has been taken on the basis of that order? Has that order been implemented? Because it has not been implemented, it is not enough for us judges to say that, well, I've done my duty. Your duty does not end with laying down doctrine. Our duty extends to ensuring that these orders are actually implemented, and faster technology has given us that particular modality. We are experimenting with artificial intelligence in the Supreme Court. People ask me, are we using artificial intelligence to deliver judgments? As someone who has spent 24 years in the art or science of judging, I don't want a machine operated robot to write my judgment for me. The machine operated robot may give a more mathematically correct answer in a claim for motor accidents compensation. I may make a multiplication error, but the machine operated robot cannot have the sense of empathy, compassion, which a judge has. It may not have some of our failings, but even AI has failings. It has biases depending on who has designed AI. But we are using AI in a very different context. Cases are filed in our registries. Sometimes cases of a very high value are filed in our registries. The most resourced of citizens are able to ensure that their cases are fast tracked, while the cases of the poorer citizens take a back seat. I do not want to dwell into that. All of you are conversant with the reasons for that. And I thought for myself, why cannot we use AI to completely replace, as far as we can, the human intervention in the verification of cases for defects? All that is done by the registries to mark out defects, court fees not paid, every page not signed, annexures not properly printed. Artificial intelligence can do that. And we are on the anvil of doing that in the Supreme Court very shortly. Categorization of cases. When a case comes before the court, it is assigned a particular category. Depending on the category to which the case is assigned, the judge gets earmarked. Brother Sivagnanam would announce a roster for judges that for the next session, these are the judges who will deal with Section 482 matters. These are the judges dealing with criminal appeals. Now, if the lawyer has misstated the case categorization, they can doctor the judge before whom the case will come. And I have come across this in the Supreme Court, where a wrong case categorization is given, and the case therefore goes not to Judge A, but to Judge B. I'll make a good faith assumption that it was done by mistake, but it is not always the product of mistakes when the stakes are very high. And therefore, we can use artificial intelligence, which can read cases rapidly, the entire record rapidly, to at least give you a preliminary case categorization, which can enable us to manage our litigation better by clubbing cases which deal with common issues. Last point, and then I'll be done, on judgment writing. We are going to be discussing in a latter part of the two-day conference on judgment writing. I'd like all of you to spend a little time on asking yourselves one question. Who do we write for? Do we write for judges? Do we write for lawyers? Or do we write for those for whom we are delivering justice? What I'm trying to therefore emphasize is, in the way we write, our effort should be not to complexify the legal problem, but to render that problem as simple as you can. Simplicity, mind you, is not an easy art. It's the most difficult art. Because simplicity, the more simple you are, is a reflection of how uncluttered your mind is. A cluttered desk of a professional is a sign of a confused person who sits at the desk. An uncluttered desk is a sign of an uncluttered mind. And so also the art of judgment writing. We have to write for those for whom our judgments are meant. Namely, in simple language without really too much of recourse to Latin to establish our influence or knowledge of the subject. I'm sure that these are issues which you will be discussing. Last point which I want to make, which is the point on which I began, the concept of constitutional morality. Increasingly, you find judges writing about their own ideologies and judgments. I'm not saying that judges do not possess their own personal philosophies. When I was a young member of the bar, we would always say that a particular judge is pro-landlord, or we thought that judge was pro-landlord. We thought a particular judge was pro-tenant. So everybody would run, if you had a case of a tenant, to a pro-tenant judge. These are lawyers' perceptions. They're not always right. They're sometimes right, they're sometimes wrong. But the most important thing is how we as judges convey the work which we are doing. For instance, I find judges writing about the fact that I will not give a direction for protection, police protection to a couple, merely because that couple was in a consensual relationship outside marriage. But our law protects relationships in the nature of marriage, which are not exactly marital relationships. Yet you find judges writing that if you have not entered into a marriage and you are yet staying together, I as a judge will not grant a direction of protection of that couple, that young couple, even if there's a risk that that couple may be subjected to an honor killing. Is that the true nature of a judge? Or are we giving effect to our own personal ideas about what is moral or immoral in place of constitutional morality? Or you come across a case where a judge has said that, well, because this was an interfaith marriage and you had not taken the permission of your parents, I'm not going to grant you the benefit of the protection of the law. Is the judge giving rise to, giving vent to their own personal view of how society should live their lives? Therefore, above all, in the work which we do as judges, and this is my last message before I conclude, please remember that we are servants of the Constitution. We are not masters of the Constitution. We may be masters of constitutional interpretation because the task of interpretation is given to us. But we are yet servants of the Constitution. And therefore, the values which we as judges have to espouse, whether you like them or not, these are the values which the Constitution has enshrined for us. What is a just society is not my imagination of what is a just society. What is a just society is the constitutional imagination, the constitutional vision, not the imagination of a just society. That is a society which is based on human dignity, fraternity, equality, liberty, respect for all, tolerance for all, and inclusion for all. With that, I thank you very much for inviting me. I'm grateful to you.
Thank you, my Lord, the Chief Justice of India, for the address that could only have emanated from a jurist par excellence, whose legal intellect has found nirvana in the perfect syncretic union of Occidental jurisprudence and indigenous principles of justice or nyaya.
Honorable dignitaries, brothers and sisters of the District Judiciary of the participating states, ladies and gentlemen, within the next few minutes, the inaugural session would come to an end. Once the cadence of the national anthem wafts into silence, we shall proceed for a group photograph to freeze the present for posterity and then head for high tea. The group photograph would take a few minutes. We will be needing to make certain arrangements. The dignitaries on the dais would please remain on the dais. We will take 2-3 minutes for making the arrangements for the group photograph. But first we must rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे, तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे, जय 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 हे।
The first working session shall commence after high tea. After the high tea, the delegates are requested to proceed to the left. After departure of the honorable judges, the honorable judges will please proceed to the judges' lounge on the right for the high tea.